If you opened Instagram in the last few days, you saw the wave. A historic victory. 40 years of waiting, ending in Strasbourg. The official headline says Jehovah's Witnesses finally defeated the Italian state. And, technically, that is true. But while the organization's leadership was preparing the press releases, there was a paragraph, buried inside the 40 pages of the judgment delivered on June 11, 2026, that the official communications appear to have forgotten to quote. It is a paragraph that quietly dismantles the narrative being sold to the faithful. What the European Court of Human Rights ruled was not a seal of approval for Watchtower doctrine. The judges, in fact, went to unusual lengths to say exactly the opposite. They reviewed the Italian government's specific concerns about Jehovah's Witness practices, and they declined to bless any of them. They simply said the Italian state had not done its administrative homework. That is a very different ruling from the one being celebrated online. This video is about the gap between those two things, the gap between what was decided in Strasbourg and what is being repeated on social media. The gap between an administrative defeat for Rome and a moral victory for the Watchtower, which, on close reading of the judgment, never happened. And by the end of this, there's a connection to a parallel case in Norway that the organization spent 4 years losing before they finally won. A case in which Watchtower quietly changed its own disciplinary policy 11 days after a courtroom loss, and then claimed total vindication on appeal. That sequence tells you almost everything you need to know about how the institution's public relations machinery actually works. Part 1. The court that judges procedure, not theology. The case is named Christian Congregation of Jehovah's Witnesses against Italy. 7 judges. Unanimous decision. Delivered on June 11, 2026. The question put to the court was narrow. In Italy, there is a system called the intesa, a formal agreement between the state and a religious denomination. Once signed and ratified, an intesa unlocks access to a tax mechanism called the otto per mille, the 8 per thousand, which redirects 0.8% of every taxpayer's income tax to a religion of their choice. It also unlocks civil weddings, military chaplains, recognized holidays, favorable tax treatment of donations. Since 1984, Italy has signed intes with 13 denominations: Lutherans, Jews, Buddhists, Hindus. The Latter-day Saints have one. Jehovah's Witnesses applied in 1977. 3 different Italian governments signed an agreement with them, in 2000, in 2007, in 2014. Each time, the Italian parliament refused to ratify. Never formally rejected, never formally approved, just left in administrative limbo. The witnesses brought the case to Strasbourg, arguing discrimination. The court agreed. But this is where the framing starts to drift. The Court of Human Rights is not a theological tribunal. It is closer to a traffic referee than to a moral judge. It does not rule on whether a religion is correct, or healthy, or safe. It rules on whether the state, when regulating that religion, followed transparent and non-discriminatory rules. If a traffic officer waves 13 cars through an intersection and stops the 14th without giving a reason, the court that hears the complaint does not certify that the 14th car has good brakes. It rules that the officer failed his duty of impartiality. The car is allowed to proceed. The question of the brakes is, legally speaking, a separate matter, in a separate court, on a separate day. The Christian Congregation of Jehovah's Witnesses against Italy decision is the traffic case, not the safety inspection. This is not a stretched interpretation. 3 Italian legal scholars went on record almost immediately after the ruling. Francesco Alicino, professor of law and religion at University. Maria D'Arienzo, professor of ecclesiastical law at the University of Naples, Federico II. Pierluigi Consorti, professor of law at the University of Pisa. All 3, independently, made the same observation. The judgment does not create a right for any religion to obtain an intesa. It does not validate any doctrine. It does not address any internal practice. It requires only that the state, when granting a benefit, do so under transparent, non-discriminatory criteria. That distinction is the entire ruling. And it is the distinction that the Watchtower's communications team has chosen not to amplify. Hold on to that point, because in Part 3, you'll see what the court said, in its own words, about blood transfusions, voting, and military service. The 3 concerns the Italian government tried to use as a defense, and what it said is the opposite of what the press release implies. Part 2. Recognition versus neutrality. The most interesting feature of this case is not the ruling itself. It is the gap between the language of the court and the language of the press release. Read the official communications. The recurring words are recognition, vindication, fairness, equal treatment, finally heard. The framing is moral. The tone is restorative, as if a misunderstanding has been corrected and a community has been welcomed home. Now read the judgment. The recurring words are very different. Neutrality, impartiality, discrimination, procedure, transparent criteria, administrative inaction, comparable situation. These are not synonyms. Recognition is a moral word. It implies that something has been seen, judged, and approved. Neutrality is a procedural word. It implies only that the state must keep its thumb off the scale, regardless of what is on the scale. The Watchtower communication is operating in the first vocabulary. The court is operating in the second. The believer, reading the press release, is being invited to translate court language into press release language, and the translation is doing real argumentative work. There is a useful analogy. Imagine a large corporation that wins a lawsuit against a regulatory agency for being denied a business license that 13 of its competitors received. The corporation wins. The agency is ordered to process the application under uniform rules. Did the corporation just prove its products are safe? Did the corporation just prove its labor practices are ethical? Did the corporation just prove anything about its internal culture? No, no, and no. It proved that the agency was treating it differently from comparable competitors without coherent legal basis. That is the entire scope of the win. Anything beyond that is marketing. The Italian case is structurally identical. A national bureaucracy was ordered to process an application under uniform rules. The application now proceeds. The doctrines of the applicant were never under review. And this is the part the press release does not say, because saying it would deflate the story. The believer who shares the Instagram post is not sharing a doctrinal triumph. They are sharing an administrative law decision, but administrative law decisions do not generate viral engagement. So the framing shifts, the vocabulary shifts, and the ruling, on its way from Strasbourg to the average member's phone, gradually acquires a meaning the judges never put into it. Part 3. The paragraph. Watchtower isn't quoting. The Italian government did not lose this case for lack of trying. In its defense, it raised 3 specific concerns about Jehovah's Witness teachings: the refusal of blood transfusions, the historical objection to military service, and abstention from voting. The court reviewed each. On blood transfusions, the court observed that Italian law already protects the right of competent adults to refuse medical treatment, and that Italian judges already have the authority to intervene on behalf of minors. The court was not asked, and did not undertake, to decide whether the underlying doctrine is medically sound or ethically defensible. It said only that the Italian government had not produced evidence of a concrete legal problem within Italy. On military service, the court noted that mandatory military service in Italy has been suspended since 2005. The objection was, in practical terms, no longer operative. On voting, the court noted that abstention is lawful in Italy, that is the legal core, and the texture of those sentences matters. The court did not say the blood doctrine is correct. It said the Italian state had failed to demonstrate immediate harm. Those are not the same sentence. One is a clearance. The other is a procedural finding. This distinction is exactly the one the judgment cites earlier rulings to reinforce. The court relied on Jehovah's Witnesses of Moscow against Russia from 2010 and on Taganrog against Russia from 2022. In both, the court ruled in favor of the religious community against state interference. In neither did the court rule on the internal merit of the religion's practices. The pattern is consistent across 2 decades of Strasbourg jurisprudence. Courts of human rights protect the right of a community to exist and to be treated fairly by the state. They do not adjudicate whether that community is treating its own members well. That second question, the internal one, is handled in entirely separate cases, with entirely different evidence, in entirely different jurisdictions, and it is being handled, actively, right now, in several of those jurisdictions, which leads to the question the press release does not answer. If Strasbourg has now confirmed that the Italian government failed to substantiate its concerns, why has another European country, same continent, same human rights treaty, same legal universe, spent the last 4 years actively litigating those very concerns? And why did Watchtower itself, during that litigation, quietly change its disciplinary policy? Part 4. Norway, and what a quiet policy change reveals. In January 2022, the county governor of Oslo and Viken revoked the registration of Jehovah's Witnesses in Norway. The state stopped paying a religious community subsidy the organization had received for 30 years. The official reason was the practice of disfellowshipping, with specific concern for the treatment of ex-members and the baptism of minors. The witnesses sued. In March 2024, the Oslo District Court ruled against them. 11 days later, on March 15, 2024, the Watchtower's governing body announced a formal modification to its disciplinary policy. Specifically, the organization softened the language and the social application of what had previously been called disfellowshipping, allowing more contact with removed members under certain conditions. The change was framed as spiritual progress, as a deeper application of mercy, as a refinement of long-standing principles. The timing is what is worth pausing on, not the framing. A doctrine the organization defended in court was modified within 2 weeks of losing in court. The appeal then proceeded. And in March 2025, the Borgarting Court of Appeal reversed the lower court. In April 2026, the Norwegian Supreme Court affirmed the appeal. Watchtower won, but the doctrine had already changed, and the doctrine, having changed, has not changed back. Here is the question the Italian press release does not invite. If the European legal system reliably protects Jehovah's Witness practices on grounds of religious freedom, which is what the Italian victory is being used to demonstrate, then why did Watchtower feel the need to adjust those practices 11 days after a single first-instance loss in Norway? There are two possible answers. The first is that the doctrinal change had nothing to do with the Norwegian ruling and was, as the organization said, a purely spiritual development that simply happened to occur in the second week of March 2024. The second is that the legal pressure produced an institutional adjustment that the organization then framed retroactively as theological. A viewer can decide which answer is more parsimonious. The Court of Human Rights, of course, has no opinion on the question. It is not asked to. That is precisely the point. A court of procedure cannot exonerate a doctrine. It can only protect the institution's right to hold the doctrine. What the institution actually does with that protection, including whether it quietly revises the doctrine when no one is celebrating, is a separate story, told outside the courtroom by the people who experienced the practices firsthand. The Instagram post that started this is not false, it is incomplete. And in the world of institutional communications, what is omitted carries as much weight as what is published. The court in Strasbourg did not rescue the reputation of the organization. It punished the bureaucracy of Rome. The two events are being conflated, deliberately, in the press cycle that followed the ruling. But the judgment itself does not permit the conflation. The judges were careful. The press release is not. The questions about ostracism, the treatment of minors, the medical ethics of the blood doctrine, the authority of the governing body, the disciplinary policy modified in Norway and never restored, all of these remain exactly where they were on the morning of June 10, 2026. They were not addressed in this ruling. They could not have been addressed in this ruling. A human rights court reviewing administrative discrimination does not have the jurisdiction, the evidentiary base, or the mandate to settle them. What changed on June 11th was the Italian government's ability to keep one religion outside a funding system it had extended to 13 others. That is a real change. It is the kind of change that matters to lawyers, to tax authorities, and to anyone interested in how European states regulate religious minorities. It is not the change being celebrated in the press release. And the difference between those two changes is the entire story. If this is the kind of reading you want, separating legal facts from institutional narratives, paragraph by paragraph, subscribe and turn on notifications. We're going to keep watching every ruling, every press release, every quiet doctrinal revision, and explain what the official channels prefer to leave unsaid. And in the comments, tell me which line in the post struck you most. The framing, the omissions, the pattern that repeats every time the organization wins in court. The strongest comments often become the next investigation.